All rise. All persons having business before the Honorable Associate Judges, now reside of the District of Columbia Court of Appeals, draw near and give your attention. I thank the United States and its Honorable Court. This Honorable Court is now in session. Please be seated and come to order.
Good morning, everybody. Welcome to the District of Columbia Court of Appeals. We have 3 cases on this morning's calendar, and we will start with case number 22 CF 463, Dana Bruce versus United States. Counsel for Appellant Jeffrey Light will be joining us remotely. And Mr. Light, whenever you are ready.
Okay, one moment. Okay, thank you. Good morning, and may it please the court. I'm Jeffrey Light on behalf of Appellant Dana Bruce. I'd like to start this morning by discussing the sufficiency of the evidence on the large capacity ammunition feeding device charge. As this court explained in a case called McNeely, there are 4 factors that the court needs to consider in determining whether a mens rea is required for an offense. And only one of those is at issue here, which is the contextual rules of the common law. The government doesn't contest that the remaining 3 favor the appellant, and those remaining 3 are whether the crime is a public welfare offense. It is not. Whether strict liability.
Counsel, can I just interrupt you? So I'm sure I'm oriented as to what argument you're making. I mean, you have 2 different styles of argument. One is a sufficiency argument, even if regarding whether or not there was even evidence that Mr. Bruce knew that this magazine held 12 rounds of ammunition. And then there's the predicate statutory interpretation question of whether or not knowledge is a requirement. And I take it you're addressing the second half of that right now.
Yes.
Okay.
I guess I'm going in reverse order.
Okay.
Mr. Light, it would be helpful to me if you discuss our case in Moore. And let me add a little more to my question.
Sure.
The Moore case dealt with facts very much like this. The Moore case was decided after Staples was decided. It distinguished Staples and affirmed. I'm not sure I agree with the reasoning in Moore, but as a panel of 3, I think we're bound by it. So why is your case distinguishable from Moore?
Well, I think the most obvious reason is that Moore, as well as the subsequent case In re Diaz, dealt with machine guns and sawed-off shotguns, respectively. And those are 2 particularly important things because in Staples, those are 2 categories that the Supreme Court identified as being potentially quasi-suspect categories. Here, we are not dealing with either of those things. We're dealing with ammunition feeding devices. And so the question—
If you'll excuse me, in Moore, the weapon did not fire automatically. It was a machine gun only because of its capacity. And all of the 15 rounds of ammunition in Moore were contained in the magazine, which was inside the pistol. So that strikes me as like our case. Our court in Moore said the government didn't have to prove that Mr. Moore knew there were 15 rounds in the magazine.
So while I agree with you that there might have been a little bit of confusion by this court in referring to something as a machine gun that we would not normally consider a machine gun, that was their analysis. The analysis in Moore was not looking at whether it was quasi-suspect because of the number of rounds. The analysis was the Supreme Court used the word machine gun. The word machine gun is at issue here. So I think that gives this court freedom to actually look at the specific statute here, which is not the statute at issue in Moore. The statute at issue in Moore, the machine gun provision was repealed. And part of the basis for this court's decision in Moore was that that specific statute at issue there, the legislative history of it was to deal with particular items that were of a quasi-suspect character. The statute we're dealing with here is entirely different. It doesn't have that legislative history. It doesn't come along with other types of items that also would fit into that quasi-suspect classification. So what we have in this case for legislative history is the DC Council not saying specifically whether or not they intend for knowledge to be an element. So there's silence on that. The government suggests that the court should decide based on the police chief's testimony. But even if that were credited, it's notable that the chief of police never said that these high capacity ammunition clips have no lawful use. She said that about a number of other things, but not this. And so
why should we look to the legislative history? I've been browbeaten by the Supreme Court into focusing on plain language of the statute. Although DS and Moore interpreted a different statute, that statute is worded almost identically to the one at issue here, in the sense that it says in barest terms, no one in the District of Columbia shall possess. And reading language like that in light of Staples, our court declined to require proof of knowledge.
So whether or not this court was correct to look at the legislative history and more, if the court does not look at the legislative history here, there is no indication that there was an intent by the council or anything in the text to make this a strict liability offense. The court does look at the legislative history. It needs to look at the legislative history of the statute at issue, not some other statute, the relevant provision of which has since been repealed.
Counsel, can I just, in what respects, it's a very basic question, because we're talking about statutory interpretation. And really the question is, did the trial court err in some respect? So you have two arguments. One is, well, the evidence was insufficient to prove that he knew. We're not talking about that. The second one, I take it, is a response to a jury note that the jury was improperly instructed. This is sort of the framework for your argument. The jury should have been told that they had to find that Mr. Bruce knew the magazine held more than 10 rounds. But as to that claim, you didn't make an argument like that before the trial court, did you?
Well, there's actually also a third claim on that theory of ineffective assistance of counsel for not making that argument. The trial counsel simply said, no, the government doesn't need to prove it. So we agree that it wasn't preserved, but I think the easiest route for the court to go, and the route that the court has to go one way or the other, is looking at the sufficiency of the evidence. Because even if the court agrees on the instructional error, it would still need to determine whether there can be a retrial on it. So it still needs to reach sufficiency of the evidence, which is extremely weak here. The government alludes to facts that they contend suggest that the defendant knew that the gun was loaded, but they never suggest that there are any facts that point to him knowing that it was loaded with 12 bullets. And there's notable lack of any evidence in this case that would support it. There's no DNA or fingerprints on the magazine. There's no evidence as to how he got the gun. A gun, unlike the machine gun and sawed-off shotgun, you wouldn't be able to tell from just looking at this pistol how many rounds it contains in the magazine. And that was something that was of importance to this court in deciding both Moore and DS. And so the government's evidence on this is is simply insufficient. And perhaps that is why the jury asked that question. They recognized that there was not much for them to go off of there. And in fact,
Counsel,
go ahead.
in your reply brief, you argue that voluntarily and on purpose, not by mistaken accident, is the functional equivalent of knowledge. And so you seem to be saying that the instruction here does contain a knowledge requirement. And so essentially the jury was instructed on a knowledge requirement and then was given a perhaps confusing, in your view, confusing response on its note by the court. But under a plain error standard, seems like you're acknowledging that the jury was at least initially correctly instructed. So where's the plain error?
So the jury was correctly instructed in the sense that they were not incorrectly instructed. There is a knowledge requirement, and the Red Book says that. What is unclear from the Red Book requirement, or from the Red Book statement, is whether that knowledge requirement applies to every element of the statute, or just one, just knowledge of possession. And so the plain error here was the trial court failing to recognize that it applies to every element of the statute. And that would have been obvious in light of cases from the Supreme Court, like Torres, in which the Supreme Court specifically reaffirmed that the knowledge requirement, the mens rea requirement, will apply to every element. And this court's decision in Carroll to the same extent.
But this goes back to Judge Fisher's question. How can we say that would have been plain to the trial court in light of Moore and in light of In re DS, where despite those general pronouncements that you have to have knowledge as to every element, we said, well, not when it comes to a 15-round clip and more, that is what made the semi-automatic weapon a machine gun, I think, under our law, even though I think that gun people might not use that terminology. And so Moore's at least very close to this case. So I have a hard time seeing how the argument holds water that it would be plain error to think that Moore controlled the question, as defense counsel thought.
So there isn't really much of an explanation in the record as to why the trial court reached the conclusion it did. It didn't say anything about Moore, but it should have been obvious that this is not the statute at issue in Moore. And
for sure, I mean, it is a different statute, but the reasoning is it's a very slight extension from Moore to conclude that because you didn't need to have knowledge of the quality that made the gun a machine gun and more, that being that it had a 15-round clip, it would make sense that you wouldn't need to have knowledge of what made this clip a high capacity ammunition feeding device, which is that it held 12 rounds. I mean, again, I think, as like Judge Fisher said, I'm not sure how convincing Moore is in light of Staples, but we said it's a holding. And this feels like just a really short distance from Moore, even if they concern different statutes.
well, if the court was following the rationale in Moore, it would have seen that Moore said a machine gun was at issue in Staples, a machine gun is at issue here. So that's the reasoning. It wouldn't have thought a high capacity magazine was at issue in the Supreme Court. And so it's at issue here. So those are very different things.
I mean, it's not very different, though, because that's the only thing that made it a machine gun in Moore.
Well, one of them is 12 rounds and one of them is 10 rounds. And there's a distinction because, as I point out in my brief, capacity of 10 rounds and greater is in common use. I'd like to reserve the remainder of my time for rebuttal.
All right. Thank you, Mr. Light. We'll now hear from counsel for the government.
Good morning, Your Honors. May it please the court. Mark Hobel for the United States. the trial court did not plainly err in responding to the jury note about the large capacity magazine. It did not err at all. More governs this case. Judge Fisher, you asked Mr. Light whether we need to look to legislative history or should start with the plain text. We start with the plain text. Textually, the large capacity magazine statute does not include a mens rea requirement, as Mr. Light conceded in his opening brief. It does not contain the word knowingly.
On the other hand, we insist on mens rea in the sense that we require knowing and voluntary possession of the magazine.
That is correct, and that's an interpretation that that's how this court has construed the word possession, which is in the statute. But in order to get to the knowledge of the operative characteristic, we lack that word knowingly. So the next kind of textual step in the textual analysis is to look to, is there a presumption of mens rea? Under federal law and Staples held that in construing the federal machine gun law, there was a presumption of mens rea. However, under this court's precedent in re DS and more, this court held that there is no such precedent when interpreting a similar ban in which machine gun was defined by its ammunition capacity, just like this statute. So in fact, the presumption in our law, whether as a matter of first impression this court would reach or not, as a matter of precedent.
Why would we have a different presumption, given all the reasons that the Supreme Court provided for the presumption in Staples, which aren't really jurisdiction based? They are first principles based, and they are, I mean, there wasn't really a constitutional basis in Staples per se, but there was certainly concerns about notice and similar concerns.
Well, that's correct, Your Honor. And in more, this court actually addressed Staples directly and said, under the statutory scheme that Congress enacted for the District of Columbia, anyone who knowingly and intentionally possesses a weapon in this jurisdiction does so at his or her own risk. In effect, the law obligates such a person to make sure the weapon is not of the prohibited variety. The Moore court specifically addressed the Staples statutory presumption, said there is a different presumption that applies here under DC law. We are construing Congress's acts and the council's acts differently here. And that precedent is binding and governs this case because as Mr. Light acknowledges, the way that machine gun was defined in Moore was based on its ammunition capacity. And in fact, if you look at, and this is sort of a third principle of textual analysis that favors the government here, if you think about the reenactment canon, the presumption that the legislature is aware of the court's precedents when it enacts a new law, well, a year, I think it was in fact the same year that Moore was decided, the council enacted the large capacity magazine statute, banning high capacity magazines in the same way that the machine gun statute that was at issue in Moore was addressed to ammunition capacity. So that's a third textual principle that favors the government here.
Let me ask you about a feature of this case that makes me wonder whether we should follow Moore. Since the record was recently supplemented, we have a couple of nice photographs of the firearm. And this magazine fits precisely into the hand grip of the pistol. It does not extend below. It looks like this pistol was made to hold a 12-round clip. So by looking at this firearm, there is nothing to alert Mr. Bruce, arguably, that there is anything unusual about this magazine.
I think that's visually and factually that's correct, Your Honor, but I would direct this court's attention to footnote 17 in the Moore case, which addressed a similar issue, which said, look, our holding in re DS seem to rely on the visual characteristics of the item. But in fact, we're really talking about a statutory presumption against mens rea here. There may be affirmative defenses, none of which apply here and haven't been raised here, that would address some of the innocent possession and so forth. But footnote 17 and more directly addresses Your Honor's point, which is.
So how do you, I've read that footnote with interest, and how do you think that affirmative defense would work? Would it be like self-defense, that the defendant has to raise it, but once raised, the government has to disprove it? In other words, the government would have to prove knowledge here if he claimed lack of knowledge?
Yes, but I think that the specific affirmative defense that footnote is alluding to, they cited to the Worthy case, a precedent of this court from 1980, which is addressed to, and Worthy and the cases it discusses address innocent possession. So what happens if you see a gun or a large capacity magazine lying on the ground and you want to keep it out, by a playground, and you want to keep it out of the hands of kids? So you're possessing it knowingly. In fact, you know what it is, but you're taking it to a police station. So what you're doing is in the public good, and it's for public safety reasons. That is an affirmative defense. I don't think.
But innocent possession doesn't strike me as relevant here.
It's not relevant here, but that's the limited nature of the affirmative defense that footnote 17 is talking about it more.
No, I mean, it says excusable ignorance is the affirmative defense it's talking about. You're not discussing, I mean, the ignorance is never excusable unless some other affirmative defense applies. Is that your thinking?
Well, mistake of fact can be a defense where there is a mens rea element. Here, there is no mens rea element with respect to the ammunition capacity. I'm not sure to what extent, the Moore court was, I think the Moore court was sort of suggesting there may be limited affirmative defenses of the sort that I've already addressed. I don't think it was trying to make a more general point about, or going beyond that. And certainly no affirmative defense has been advanced in this case.
I guess, could you just maybe let's talk a little bit about whether or not Moore makes any sense. Because one way of looking at this is we have Staples, a Supreme Court case that looks very similar to this and says, in particular, because the thing that made that gun, machine gun, was a hidden characteristic of it that the jury could have found the defendant didn't know about. Same is true here. It'd be quite easy to find that the defendant didn't know this was a 12-clip magazine. And Moore's leans heavily on In re DS, and In re DS's reasoning as well. Anybody can see if a shotgun barrel is less than 20 inches. Okay, and I guess one way of looking at it is, sure, Moore controls as to whether or not something is a machine gun under the statute that it was interpreting, but whether or not it should be extended to a new statute should depend somewhat on its persuasive force vis-a-vis Staples. So I wonder what persuasive force you think it has, because I find it somewhat lacking.
Moore is addressed to the specific characteristic of the item, the capacity that is at issue in this statute. And in fact, if you look at the legislative history, if you think there is ambiguity, you can turn to the legislative history. And the committee report makes clear that the large capacity magazine ban is a direct descendant of the machine gun ban in Moore. It is a statutory successor, because after the Heller decision by the Supreme Court, the district rewrote some of its gun laws, had to reformulate them. And part of the problem with defining a machine gun as a semi-automatic handgun capable of holding a certain capacity ammunition is you ended up banning the handguns, even if they didn't have the magazine in them.
Right. Every semi-automatic handgun could be a machine gun under the prior statute. All you have to do is, it's capable of taking a 15-round clip, right?
Yeah. I don't know of any, but I imagine that, yeah. Yes. And so, but the council, after hearing testimony from the police chief and others, was still incredibly concerned about high capacity rounds, which it said in its committee report are more about firepower than self-defense. And in order to it give a critical advantage to law enforcement, the council chose to ban large capacity magazines in the same way that it had banned large capacity guns under the Moore statute. It was solving the problem that the rewrite of the Moore statute created. And, you know, Mr. Light points out, well, I think in his reply brief, something to the effect of, you know, if the council really thought that large capacity magazines were devoid of lawful use, wouldn't they have said it clearly? Well, you can't say it more clearly than banning them outright, which is exactly what the council did here.
But isn't there a huge qualitative difference between a hand grenade and a sawed-off shotgun on one hand and a magazine of ammunition on the other?
I ultimately think that that is a legislative and policy decision. And for our purposes here, the council has determined that there is not. Reasonable minds could differ, but the council has spoken, and the council was aware of this court's, we presume it was aware of this court's precedent in Moore interpreting a capacity ban as not requiring mens rea. I want to make sure that I emphasize too, if the court is at all troubled by this, we're on plain error. And as Judge Deal pointed out, you can't say that the trial court made a clear and obvious and blatant error given the strength of the precedent and under In re DS and more. Even if you think these are thorny issues, that cuts in favor of the government here. I see at this point, I see my time is almost up. Unless the court has any further questions, we would ask this court to affirm Bruce's convictions.
Counsel, I would like to focus a little bit on the jury striking, of course, issue. Wasn't the trial court obligated to ask one or two further questions of this juror during voir dire to suss out whether she was actually going to be unwilling or unable to follow the court's instructions and render an impartial verdict based on the evidence? That question was never really asked, right?
You know, I don't recall. So I suspect in those terms, no, it wasn't. I don't specifically recall, but the answer to your question is no. And certainly Mr. Bruce has not raised any claim of error related to the adequacy of the voir dire. He's challenging the excusal for cause itself. And based on this record and the statements of the juror, which I think you know are fairly straightforward. This juror, I know, was a lawyer, was speaking candidly and openly and out of abundance of caution, and indicated, and again, to her credit, I think, indicated, you know, she was probably going to give less weight to police officer witnesses, the evidence they provided, because they're police.
But Mr. Light argues that she was rehabilitated. And when I read the transcript, there is at least some of that apparent on the record that she said, well, you know, I could probably be fair and impartial.
Yeah, I think the defense counsel asked sort of a vaguely worded question at the end that you know, the trial court took into account, and the trial court said, well, she said she was skeptical, we're going to be more skeptical of police, and she didn't take it back. And that is not clearly erroneous on this record. She did not take that back. She was clearly struggling with the issue, but, you know, and this is an area of law where trial courts are entitled to considerable deference from this court, because they have an opportunity to evaluate the whole picture and the demeanor of this juror, the entirety of the answers, and the judge here did that fairly. And, you know, Judge O'Keefe, you know, he emphasized that he was going to apply that rule fairly. And he did. He struck two jurors who indicated they would give police officer testimony more weight than any other witness. And he struck two jurors, including juror 16, who indicated that they would give police officer testimony less weight.
Do you think that's true? I thought too, when you say they would give more weight to police officer testimony, my recollection is one of those witnesses you highlight says something like, I have police officers in my family, I would hold them to a higher standard. That doesn't sound like they're giving their testimony more weight. It sounds like they might be more scrutinizing. officer testimony. Am I misremembering? the-
Yeah, so I think juror 50 said he held police, he was a former officer and held police at a higher level than most people. So I think his statements were directly directly said they're entitled to more. And he answered the question, which was, would you give a police officer more or less weight?
You're right. In fact, he follows up. I think they have earned that trust from me.
Yeah.
Fair enough.
Yeah. So unless the court has any additional questions, we would ask this court to affirm Bruce's convictions.
All right, thank you, counsel. All right, Mr. Light, we will give you a few minutes for rebuttal.
Thank you. Just one brief thing I wanted to say about the ammunition feeding device is one thing that's changed since Moore is this court's en banc decision in Carroll. And that's notable because one of the modes of analysis relied on by the court in Moore is whether this is a general intent statute. And in Carroll, this court has criticized the use of that terminology and emphasized the need for a mens rea on every element. And turning to the issue of the juror selection, I think that it's pretty straightforward that the judge confused the concept of skepticism with bias, and that he therefore adopted an overly expansive view of what jurors should be struck. And in light of that, I cite to cases in some other jurisdictions upholding that, but I think skepticism is an important thing for jurors to have. It's part of their process of evaluating credibility, and it's based on their life experiences. On the other hand, when this court talks about bias and not being able to put bias out of the way, that is something more like an unfounded stereotype. But even then, the question is not whether a juror is biased, it's whether they can put it out of their mind. And as far as whether there were potentially other questions the Superior Court judge could have asked, that was up to the court and the government. The government was the party arguing that the juror should be struck, and therefore the government was the party bearing the burden of establishing the record on that issue. It certainly may have behooved the trial court to have gotten some more information, but that is something that runs against the government on the current record. I would also say that this case very closely mirrors the situation in Mason. There isn't a lot of difference between the two cases, and for those reasons, we urge you to reverse.
Thank you, counsel. We appreciate the parties' briefs and their arguments, and the case is taken under advisement. Next up, we have case number 22 CV 593 KS Condo LLC versus Fairfax Village Condominium. Counsel, whenever
morning.
you're ready.
And may it please the court, I am Jonathan Stern. I represent KS Condo. And I would ask to reserve 4 minutes of my time for rebuttal. The trial court in this case held KS Condo to an unreasonable burden of proof after a bench trial. And it did so by requiring an expert on the standard of care of the condo association, by requiring an expert on the breach of the standard of care, by requiring an expert on the cause of the collapse and the absence of intervening factors, and by placing the burden on KS Condo to prove the ability of the condo association to pay for the necessary structural repairs. So I'd like to start with the expert on the standard of care. The law is very clear. The issue for requiring expert testimony is whether the particular issue is so distinctly related to some science, profession, or occupation that it is beyond the average layperson's understanding. The trial court in this case did not address the particular issue. The particular issue in this case was, once a condo association has recognized that an urgent repair is needed, that it has to happen immediately. In fact, in March of 2015, they said we need to do this within the next 30 days or we risk lawsuits. They had structural engineers come and inspect and advise them that indeed they were correct, that the foundation wall was at imminent risk of collapse, and it needed to be addressed immediately or it likely would collapse.
Mr. Stern, I think your opponent's brief does a pretty good job of responding to what you're saying by saying it's more complicated than KS lets on. Everything was falling apart in this area, and there were a lot of things that needed repair, some urgently, and there wasn't money to do it. So why wouldn't you need a property manager or somebody versed in that sort of juggling of obligations in order to enlighten the trial court?
Yes, Your Honor. The answer to that, I think, is that, well, it's twofold. First, the board is comprised of laypersons, of owners of condominium units. And there is no specialized, in the words of the rule, science, profession, or occupation so distinctly related that type of expertise is necessary. It's not beyond the average layperson's understanding. Homeowners juggle those types of things all the time. They prioritize the more important repairs over the less. Structural repairs, when there's imminent risk of collapse, obviously goes above painting, which was one of the other projects that was on the urgent list. Fairfax Village, in its brief, said that there were 18 projects on the list at the outset of this, 3 of them urgent. One was ours, the collapsing foundation wall in the basement of 3810 V Street. The other was an exterior paint job at 2006 38th Street. The third was a drainage project. And if you look at the very next board report in the appendix, which is at page 202 of the appendix, it reflects that the other 2 projects had been completed, and that report was from May of 2016. So long before this wall collapsed, the 2 other urgent projects had been checked off the list. But again, I think this is not an area where specialized science, occupation, profession is necessary. I think it's something.
So the trial judge in this case should have just swallowed hard and weighed all the facts and decided whether this was negligence or not.
The trial judge, in our view, the trial judge had no choice but to find that it was negligence, to allow something that had been recognized as requiring immediate repair 2 years and 4 months earlier, saying we have to accomplish it in 30 days. And with respect to the money.
Can I just pause there, because your argument, your request for relief in your brief is not one for a directed verdict, as it would seem to be if your position were that the judge had no choice but to find negligence here. But in fact, in your brief, you asked for a new trial. Are you pivoting? Are you changing your request?
No, perhaps I should have sought that relief, but it was my view at the time that this would require a new trial because it would be necessary to go back down on damages. But I really am of the view that you know, if,
Can I ask one other question? I'm sorry if I.
Certainly.
John, Judge Fisher, did you get an answer to your question or have I interrupted? I apologize if I have. To what extent can your client benefit from any negligence that took place prior to the purchase of the condominium? And by that, I mean, we're talking about March 2015. The bulk of this delay to February 2017, to the extent they violated some duty to repair, it was not to your client, it was to prior owners. Aren't you restricted in terms of your negligence claims to sort of the February 2017 through July 2017 period, during which the condo association was quite active in trying to secure a loan? And it was really the period prior to that there was some dithering, you might say.
well, I guess I would say until there is damage, there is no cause of action. My clients owned the property months before there was a collapse, and had appropriate actions been taken in a timely manner, it's true, it would have been repaired before they ever owned it, but it wasn't, and there was still time to act. So that would be my response to that query.
Counsel, if Fairfax Village in fact had no money and no ability to raise the funds here for one reason or another, and I know you take issue with that, what role would that play? Where would that factor into the analysis? Would that negate negligence? Would that, I mean, it seems like you're saying that doesn't factor into the standard of care question.
So I frame it as a burden issue. In my view, the burden, it would be like the affirmative defense of impossibility to a breach of contract claim. It would be the burden of the association to alert the parties to, and then carry the burden on proving the inability to fund the repair. The fact of the matter is, we know that they were able to fund the repair because after the collapse, they had to apply for a loan and within 3 months had in hand $1 million, whereas this repair required $250,000.
Let me follow up on your point. You seem to be saying that if the condominium association had raised the affirmative defense and proven it, that would be a defense to an action in negligence, correct?
I think I have to concede that impossibility on that basis would probably be a defense, yes.
Okay.
Yes. Although I do wonder what would happen in the situation of a landlord, and a condo association is deemed in the law to be the landlord to the association and owes fiduciary duties to the owners. What would happen if you had a similar situation? You had a collapse, perhaps it took lives, and the landlord defended on the basis that it was either too painful or, I'll say, impossible to raise the money. But again, I go back to the point, we know it was not impossible. We know that no application for a loan had been made until April of 2017, more than 2 years after the problem was identified. We know that within 3 months of the collapse, $1 million was in hand. And we know that despite talking for 2 years about issuing a special assessment, no special assessment was ever issued.
Counsel, pivoting to causation, the trial court sort of made an alternative ruling on that basis. Could we affirm on that basis without reaching the expert testimony question? And I guess the question is, without you having presented an expert on causation, it's theoretically possible that this building was going down one way or the other, right? Someone that maybe the Fairfax Village would have spent $250,000 for nothing, and this thing was coming down. It was too late. How would the trial court be in any position to know whether that's the case or not?
So if this were a criminal case, that might be an appropriate position, but this is a civil case and the burden on the plaintiff is a preponderance of the evidence. The plaintiff does not have to rule out all possibilities. We have to look at what's likely. And what we know here is that the structural engineer came in January of 2016, so a year and a half before the collapse, and said, here's what you need to do. You need to put up steel braces to support this wall. Is it possible that something could have happened, that even if you had put up the steel braces, it would collapse? Sure, it's possible. Is it likely? No, it's not likely.
You haven't used Latin, but are you saying res ipsa loquitur?
It's been a very long time since I was in law school. I do know what res ipsa loquitur means, but no, I'm not saying that. I'm saying that my client does not have the burden of saying lightning could have struck. Here's why it didn't. Here's why it wouldn't have. The fact of the matter is it's just common sense. If a wall is collapsing, if you brace it, it's going to prevent a collapse. If you repair it, it's not going to collapse.
You might say it's common sense then for KS Condo not to rent that apartment to a family because that place was coming down.
My clients didn't know that. They did not know that.
I was curious about that. Why not? I mean, did your clients inspect the condo before purchasing it?
I don't think they did.
Yeah, that's an odd choice.
Understood, but
Again, I mean, it might be although, I mean, this is not the basis for the trial court's ruling, so maybe it's neither here nor there, but it might be cause to omit any consideration of the delays from March 2015 until the purchase of February 2017. That, you could have done your own investigation, you could have done your own inspection to see that this thing was in disrepair, and you didn't. But I take it they didn't raise a defense like that. I don't know, maybe it's floating around in the trial record, but it's certainly not before us, I guess.
and I would think that would require expert testimony to say that a buyer, there's some standard of care for a buyer to conduct pre-purchase inspection, regardless of the price of the property or the opportunity. But as you say, Your Honor, it's not an issue in the case. It's not been raised.
Can you pivoting back to the duty of care and whether or not the standard of care was breached. A lot of this fight is about whether or not there needed to be expert testimony. And let's say I agree with you that there didn't need to be expert testimony. This is stuff that's perfectly understandable to lay people. What non-expert testimony was there that the condo association acted unreasonably? Was there a lay witness who said, look, I've been doing this a long time, and when a repair is urgent, you don't go shopping around for loans for 2 years. You get the thing done. Or is that also something you just want the trial court to draw an inference on?
I presented a timeline during the opening statement and then in the submitted proposed findings of fact and conclusions of law. And I believe that the timeline shows that, because most of this case is established by the admissions of the Condo Association Board. They're the ones who said this has to be done in 30 days or we're going to get sued. This is at great risk of collapse. I don't think I need an expert or a lay person, if that would even be permitted, to testify as to a reasonable standard of care. I think it's something that common citizens can assess. And as I said before, I think there's really only one conclusion. If you have a foundation wall that's at risk of collapse and you've been advised by the experts, the structural engineers, that this has to be done right away or it's going to fall, I'm not sure you need more than that.
Am I correct that you do not make any attack on the trial court's alternative ruling that even if you had established negligence, it would discount 9 months of rent from any damages award? And is that now, having failed to raise that, would that sort of be law of the case from here going forward?
I think that probably is law of the case. We chose not to appeal that finding because we felt strongly about these other findings being clear error as opposed to that one.
Okay.
Thank you.
Unless my colleagues have any further questions, we will hear from counsel for the association.
Good morning, Your Honors. May it please the court. My name is Tom McGavro. I'm here on behalf of the association. I would like to start off by simply noting the two standards of review that are applicable here. As this court has said previously, whether or not to require expert testimony lies within the trial court's discretion. And as Code Section 17305 says, when there's a bench trial, the trial court's findings will not be reversed except where the judgment is plainly wrong or without evidence to support it. So a strong presumption that Judge Ross got it right.
Can we start with causation? And you want to just tell me why the judge didn't plainly get that wrong? Here's the evidence. In 2015, in March 2015, you've got a fix this wall within 30 days, it's in trouble. And then you've got report after report saying this thing's going to collapse if we don't fix it and shore it up. And you've got engineering reports. And then in July 2017, lo and behold, it collapses. How is that not by a preponderance of the evidence showing that the two things are causally related? I mean, there's no other explanation for it that's being offered by anybody.
Except, Your Honor, what caused the collapse? There are reports saying this is structurally unsound, but it stands. From May 2015 to July 2017, there is a problem, but it has not collapsed. Then in July 2017, after a hard rain, it collapses. How hard was that rain? How much water fell?
Are there rains hard enough that collapse buildings with good structural supports?
May I remind the court of the deluge in, was it 2018? When 5 inches fell in an hour? I had cases where entire garages were flooded out. The Rock Creek Parkway was underwater. Yes, there are rains that can cause severe threats.
The collapse of buildings that have good structural supports and rains cause those collapses.
I don't know about collapses, Your Honor, but it caused a whole mess of damage.
But that's the question, right? I mean,
Well, in this particular instance, but what the evidence lacks is, did that rain cause it to collapse? Would it have collapsed even if it were a bright sunny day on that day?
Are these theoretical musings? Or is there any evidence in the record about the ferocity of this rain?
That's exactly the point, Your Honor. There is no evidence. Plaintiff bears the burden of proof by the preponderance of evidence. He's absolutely correct about that, but he bears the burden of proof. And there is no evidence in the record to suggest either that this wall was going to come down on July 27th anyway. Or that there was a severe storm that precipitated it, or that there was some other cause that brought it down on that particular day. It had stood for 2 years as the engineers provided plans and they sought bids and everything else. Why that day? Why?
Who cares? Who cares why that day? Maybe it was precipitated by a rain. But walls in good condition should be able to withstand torrential downpours the way that every juror knows that, because they have houses that they live in or apartments that they live in. And sometimes there are heavy rains and their houses don't collapse. So that's what I mean. You're speaking in terms of theoretical possibilities that maybe if they had repaired this, it still would have collapsed. I mean, I guess I would have to grant you that as a theoretical possibility.
Yes.
But as a preponderance of the evidence, how could one not conclude that the crumbling wall that everybody's telling them is going to lead to a collapse of the building, and then the building collapses, that there's no causal relation between those two when there's no evidence as to an intervening type of an intervening cause, maybe a precipitating cause. It's a double entendre when we're talking about rain. But it's not, there's a good wall withstands a rain.
Quite honestly, Your Honor, a good wall withstands a normal rain. A good wall withstands a thunderstorm. But does a good wall withstand a hurricane? No,
I
I
mean,
suggest.
there wasn't a hurricane, counsel. It's sort of a wild argument. Nothing prevented you from putting out evidence of, a car ran into this wall on that day. I mean, so they've passed a preponderance threshold by some leaps and bounds.
Well, Your Honor, I understand the court's point, and the court is absolutely correct that in a normal rain or even a hard rain that we get in this area, a good wall would not collapse. However, there had been rains before on this wall. Why did it collapse at this point? Certainly, to put the question a different way, what was it about the condition of the wall at that point that made it collapse in the rain?
That it was crumbling and no repairs had been taken.
But it had been in rainy conditions before that.
But the wall wouldn't have fallen until the wall fell. I mean,
Yes.
by definition, and you wouldn't have a lawsuit until the wall fell. I mean, I don't think this is the hill you want to die on.
I'm trying not to, Your Honor. No, and I think the court's finding on, as Your Honor noted, was on causation was an alternate finding. I think the main thrust of the court's finding was there was absolutely no expert testimony. And I want to emphasize here that we're not talking about what that particular board or set of boards, because we're talking multiple years, what that particular board did or didn't do. Or what
You say we are not talking about that?
we are not, the need for expert testimony doesn't look to what the board did or didn't do, or what those individual board members were thinking. The need for expert testimony is what a reasonable board in this situation should have done.
Maybe those two are linked. That one might say that a reasonable board would not have dithered for 2 years or more in the face of this urgent need for repair, and that maybe that extreme foot dragging or dithering excuses the need for expert testimony.
Unfortunately, Your Honor, and I get back to Your Honor's point from before, that this association was lacking funds. It had not only a dire financial situation, but also multiple other repairs. There were, and I would direct the court's attention to app 411 to 417, which is the last board report before the collapse. At that point, they needed to increase security because the intercoms were broken and they weren't getting funding from they weren't getting FHA loans for years. Their insurance and premiums had increased because of numerous claims. They had at least 5 separate repair projects that they deemed to be urgent. That's excluding.
Can I ask a predicate question before we get into the argument that financial hardship made this course of action reasonable, or that the court could conclude that? To what extent, now I hear counsel on the other side concede that financial impossibility would be a defense to a negligence suit. To what extent is financial hardship? If you're a tenant and you've got an unsafe premises and your landlord says, I'd love to help you out, but I'm out of money right now and I'm not going to get around to fixing the dangerous condition in your house for a couple of years. Does that operate as a legal defense to a negligence claim? I mean, isn't the duty to fix unsafe conditions and saying, I don't have the money to do it, where does that factor into whether or not negligence, whether or not the duty was breached? Sell the house. I mean, sell the condos. If you can't afford to keep them up, I don't understand why that's a defense to negligence.
Well, there is one fundamental difference between a landlord and a condominium association. The landlord is a separate business. It certainly could just sell the building. You know what? I can't keep this up. It's not safe to live here. So I am going to put it on the market. TOPA jumps in. Do you all want the first right of refusal? No, you don't want to live here either? Fine. We sell the building, tear it down, put something else in. The landlord can do that. The condominium association can't because it doesn't own the units. If a unit owner thinks it is unsafe to live in their unit and needs to be sold, they're the ones that have to sell it.
I mean, I suppose the condominium association could let owners make their own repairs if they wanted to. They could adjust the terms. I mean, I'm not sure.
It is extraordinarily dire situation because then you've got Joe with a paintbrush down in the basement dealing with a crumbling wall. That's not going to work.
But I suppose the question for us is not, so let's assume that financial hardship could in fact excuse a failure to fix something like this. What evidence was there that waiting 2 years on something that was declared, that was said, this is urgent, you got to do it in 30 days. What evidence was there that that was reasonable? I mean, let's put aside the expert issue.
Sure.
I would love to hear your defense of why you need an expert to speak to that. Actually, why don't we start there? Why do you need an expert to speak to that?
Why do you need an expert? Because it is, the question is not whether financial hardship is an excuse. The question is whether or not a board facing a very, very tight budget, facing a crumbling infrastructure, facing the need for repairs, facing a number of unit owners who aren't paying their assessments, what is the course of action that a reasonable board in that situation should take? Now, if it is if somebody had come in and said they got no choice, they got to deal with this, a reasonable board would have done X, Y, and Z.
But how is that not the case in every negligence case, including cases where we've said no expert testimony was required? I mean, in DiStefano, where we said no expert testimony was required, that's where the child fell down the parking garage chute.
Sure.
The defendant there could have said, you're talking about a cost benefit analysis at the end of the day. Why couldn't we have said the defendant had to come in and say, we're a parking garage. We've got 20 different things to do in this garage. We've got, we didn't have any staff on hand to cover up that hole that day and X, Y, and Z. Why couldn't in the park case where the kid's finger got cut off, DC have come in and said, DC is strapped for cash. We, didn't fix that particular park at that time, but we had 20 other parks to fix.
Well, I think in both those instances, it was a clear, dangerous condition. Let me back up. In both those instances, it was, as I was about to say, a clear, dangerous condition that they did nothing about. And I understand the immediate objection is going to be, well, so is a crumbling wall. Understood. But again, we're
serious in all caps needs to start within 30 days.
Yes.
In March 2015. That's
and if I can pivot briefly to the second point I was going to make, which is there's no evidence of what they did or didn't do. There's only evidence of the passage of time.
right. I mean, you could have put that. I mean, how again? And just another quote: "We cannot overemphasize the danger of the condition."
Yes.
That's still almost 2 years before any action is taken. Like, what universe can KS Condo present affirmative evidence of what? You guys can present evidence of what you did if you did something.
Yes.
All they've got is the passage of time because they have no evidence that you did anything. So you're sort of faulting them for not proving negatives.
It's no, because
Foreclose the possibility that we did something, plaintiff.
they
That's
could have-
evidence in you. I'm sorry to interrupt, please.
I'm sorry, Your Honor, I cut you off.
No, it's not my mistake.
They could have presented evidence as to what the board, they could have presented evidence as to what the board was thinking, what it did, when it actually retained Fisher, how long it took Fisher to actually get on the job site. Was that delay because Fisher's schedule didn't allow them to get in? Was that delay because the board never got around to scheduling it? Was that delay because of all of these questions? I understand are not in the record and they are theoretical at this point because the plaintiff did not prove its
But do
case.
those go to the standard of care or are those some sort of defense to why the repair didn't happen? I don't know what prong of the negligence, and
It would go to a affirmative defense if the plaintiff had demonstrated the standard of care. A reasonable board in this situation would have, within 30 or 60 days, retained an engineer. A reasonable board in this situation would have, within 60 days after retaining the engineer, made sure there was an inspection and they got a report. If they didn't get it in 60 days, they would have gone out to a reasonable board would have done X, Y, and Z. There's where the standard of care comes.
And
Then you get to
tell me why you need an expert for that again, because the people who are making those decisions are not really expert in anything. They're residents who make up the association board.
yes.
So if they can piece things together about what's reasonable and what's not, why does a jury need to hear from an expert about that?
Two answers to that, Your Honor, and I've run out of time, but I will address this question if I may. Two answers to that. First, because that is the standard of care within a particular industry or condition. The community association industry. What does a reasonable CA property do? The second answer to that question, Your Honor, I think gets more to this particular point. Judge Ross was both judge and jury. He was the fact finder. He took all the evidence. He considered all the exhibits. There was nothing that was excluded and almost nothing in testimony that was excluded. He got findings of fact. And at the end of the day, in fact, during the trial, he said, I'm not going to grant a directed verdict because I'm not sure an expert is needed. At the end of the day, he sat down and he said, you know what? I'm the fact finder. This is beyond my ken.
Right, but then
You need
you're
an expert.
effectively saying that in any one of these cases that goes to a bench trial, that it's beyond appellate review.
If, depending on the facts of the case and the specific evidence that goes before the judge as the fact finder, the next case that comes before Judge Ross, he may very well say, no, I don't need an expert on this. Under these facts, I'm good to go. But in this particular instance, with these particular facts and this particular evidence, Judge Ross felt that it was beyond his ken. And getting back to my original statement about the standard of review in these cases, I'm not sure any one of us can check his work.
Well, we can.
Well, but under the standard of review, I'm not entirely sure that this was an abuse of discretion or so plainly wrong as to require reversal. For those reasons, and I apologize for going over.
No, please.
For those reasons, we would ask that the judgment be affirmed.
Thank you,
Thank you.
counsel. And we'll give you a few minutes for rebuttal.
Thank you.
Briefly, first of all, as far as Judge Ross being fact finder, wonderful. The facts that Judge Ross found fully support KS Condo's case. We're very pleased with the facts that were found. It's when we get into the conclusions of law that we have an issue. It's the conclusions of law based on very favorable fact finding that we come here and seek reversal for legal error. In terms of our ability to prove a negative, I don't think I have to harp on this point, but we pointed out in our brief that we had to file 2 motions to compel and were twice awarded discovery sanctions in this case because we had so much trouble getting information out of the association. With respect to the standard of care and the argument that learned counsel has made about requiring an expert, I would agree with him if we had a much shorter timeline. If we were talking about a 4-month period, then we would need an expert if we were going to prove that that was unreasonable. My position, our position, is 2 years and 4 months under any measure was way too long. Counsel raised the standard of review in this case, and I briefed it, but I just want to touch on it briefly. There's an issue as to whether or not abuse of discretion is the appropriate standard for whether or not to require an expert witness. And so we pointed out in the briefs that this court took case holdings that said that on the question of admission or exclusion of a particular expert, that's abuse of discretion. And the reason for that is that there are factors that have to be weighed and balanced. This is purely the legal question. Does the particular issue go outside of what lay people understand? And
We've clearly said that the decision whether to require an expert on the standard of care is reviewed for abuse of discretion. I mean, whether you question the reasoning behind that or not, I don't know, but we're certainly bound by those decisions, right?
absent and bank review, I
Correct.
think that's correct, but I do want to point out that in the Varner case, 2006 case, this court said in several of our decisions, however, without citing White or Davis, we have simply stated that expert testimony is required or that we agree with the trial court that such testimony is required without specifying a standard of review. In any event, in this case, we would reach the same result under a de novo standard as we do in reviewing for abuse of discretion, although the question would then be a closer one. My position is that this panel also can find under either standard that this is reversible either as an error of law or as abuse of discretion. I would ask that you reverse and send the case back for a new trial, and I thank you very much for your time today.
Thank you, counsel, for your briefs and argument. The case will be taken under advisement. And the last case on this morning's calendar is 21 CF 723, 21 CF 724, and 21 CF 725, Everett and Hewitt versus the United States. And counsel for the appellants, as we begin your argument, can you just let us know how you'll be dividing time among the appellants?
Thank you, Your Honor. Nancy Allen on behalf of NYKEMIA Everett. Your Honor's Attorney Schmidt has allowed me to go first because my plan is to cede the majority of my time to him. The government has agreed with our 4 separate merger arguments. Attempted armed robbery with felony murder while armed, the PFCV counts that attach to those, and then the obstruction counts on 2 separate dates. And as to our remaining argument, we would ask to submit on our brief.
Okay.
Thank you.
If my colleagues don't have any questions, we will hear from Mr. Schmidt.
Good morning, Your Honors. I'd like to reserve 1 minute for rebuttal, if that's possible.
Sure.
Paul Schmidt for appellant Malik Hewitt. This court should reverse Hewitt's convictions and order a new trial below. First, the trial court abused its discretion by refusing to grant a severance of Hewitt's trial from Everett's trial. It was manifestly prejudicial, which is the standard, the relevant standard, to Hewitt to be tried with Everett, given that he was prevented from presenting exculpatory testimony to the jury from Everett as a result of their being tried jointly. And second, it was manifestly prejudicial because the evidence against Hewitt was de minimis compared to the evidence as to Everett.
This hardly strikes me as de minimis when you have one of the co-conspirators testifying about your role in the robbery.
You're referring to Ms. Williams, Judge?
I am.
Yeah. So Ms. Williams' testimony, there's a couple of things that should be said about that. First of all, she took a plea deal, which renders her testimony potentially unreliable. She admitted during the trial that she had lied to the police in police statements previously. So her testimony is conflicting throughout the stages of the case, and she's also an interested witness in terms of her testimony.
But generally, decisions about severance are made before the trial begins. You're relying on things that were arguably exposed during trial. I guess there's a continuing obligation to think about severance, but at what point should the judge have severed these cases?
Our argument is, well, we don't deal with and the government mentions in its brief that the judge has the continuing obligation. We don't make an argument on that basis in terms of the trial itself, but based on what was presented at the time. Are you referring, Judge Fisher, to the exculpatory evidence or the de minimis? Because they sort of bleed into each other. I just want to make sure I'm clear. I'm answering your particular question.
My question is, trying to be, you make a decision before trial, whether
Yes.
to sever or not.
Yes.
And what did the judge know before trial that compelled him, obligated him to sever?
So with regard to the exculpatory evidence, the Fifth Amendment violation for not being able to present your case, there was a proffer made by Mr. Everett's attorney that Mr. Everett would be willing to testify that the nickname that Ms. Williams referred to supposedly Mr. Hewitt during her police interview is a common name in the Muslim community.
Could he even testify to that? I don't understand what his basis for being able to testify that is.
Well, it's my understanding that he would refer to people ad hoc, including Mr. Hewitt. So he has knowledge as to the context for these sorts of.
Well, but not that it's a common nickname in the Muslim community. I don't understand how he would have been qualified to testify about that.
It's just my understanding that Judge Shakur, that he proffered that he was willing to testify to this. In terms of his larger qualifications, I can't speak to that.
But you got in evidence like that, didn't you? Out of not just did you get in evidence that it's a common name of people that Ms. Williams knows, but you got it from a hostile witness, which seems even better than getting it from somebody who you put on the stand. So why is that so prejudicial to warrant a severance?
Well, it's certainly true that Ms. Williams testified to a Judge Deal in terms of the common usage aspect, but there's a context to that testimony that's not present with Mr. Everett's potential testimony. She, I believe, at trial indicated that she used it to sort of sully the waters in terms of whether or not she was referring to someone or Mr. Hewitt particularly. Mr. Everett's testimony, my understanding, would have been a clean, simple, this is the name commonly used, and she could have meant anything by that.
If it's that simple, why did we have to call a co-defendant to testify to that? There must have been dozens of people around town who could testify to that. We don't sever co-defendants on such slight proffers.
Well, the calling persons around town, to use your example, Judge Fisher, they're not connected to the context of this particular group, right? They can't testify as to what Mr. Everett understood by it or Ms. Williams understood by it when she
But
used
the
it.
upshot of Mr. Everett's proffered testimony was Ak is a common nickname in the Muslim community. And as I understand it, therefore, it could have been anyone.
That's correct, Judge.
That's it. I mean, it wasn't, I know it was somebody else. I know he wasn't there. So that's what Mr. Everett would have been sort of the precipient witness to with respect to exculpating Mr. Hewitt. But I guess Judge Fisher's question is, if it's the former, Ak is a common nickname and it could have been anyone, and you're saying that that's a well-known fact, then it seems like your client could have called a lot of other people to testify about that.
Well, and again, I can't argue with your classification of the record, Judge, but again, those persons could not have testified to Mr. Everett's understanding or Ms. Williams' understanding. They could have testified more broadly about something, but I mean, they're testifying, she's testifying as to her understanding, and Mr. Everett's testifying, or would have testified as to his understanding. There's one more point I want to make on this particular argument, and that is that the Rollerson case, I believe, states that, I believe it's the Rollerson case, says that even if the government has a witness that is going to testify about a similar set of facts that, might contextualize or conflict with testimony that is proffered, exculpatory testimony that's being proffered, that doesn't override the right to present the testimony. So that's just a principle I'd like us to keep in mind as we consider this. To answer Judge Williams, Judge Fisher, your question was going to the sort of pretrial knowledge and the pretrial understanding of what the record would be or was. So the second prong of the severance argument is, of course, the de minimis standard. And in terms of what we're focusing on, there's not much difference in terms of what was presented at trial versus the proffer itself. I think there was some difference in terms of the government's evidences to the cell phone location between one and the other. But for both the pretrial and the trial evidence, what was at issue was the physical identification of Mr. Everett at the scene with evidence that was incontrovertible. The video evidence of Mr. Everett at the scene, and also his jacket being left at the scene.
I think one argument I hear the government making that I'm not sure I've heard you respond to yet is all of that evidence was going to come in, or a great bulk of that evidence was going to come in had these trials been severed anyway. You know, there's a conspiracy that's running between these two men. That's the allegations. In proving up that conspiracy, in a trial that was just for Mr. Hewitt, the government still could have put on this evidence about, you know, substantiating Mr. Everett's guilt. Do you disagree with that?
I don't disagree with that, Judge Steele.
So it's hard for me to understand. So if the theory of prejudice at the trial is I was tried alongside somebody who was much guiltier than me, and the jury got to hear a lot of evidence about his guilt, I would understand that argument a lot more if that evidence wouldn't come in at a separate trial. But there's sort of, if it's going to come in the second trial, I don't understand the theory of prejudice. Could you explain it to me a little bit?
Yeah, I'll give him best shot, Judge Steele. So, well, there's two issues with that. First of all, the evidence of Everett's presence at the scene to have to physically establish his location at the scene may not have been necessary to the trial of Hewitt if they had been tried separately. That's the first thing. The second thing is there's an issue with, I think this argument largely rests on the presence of a conspiracy, right? In that, you know, what's sauce for the goose is sauce for the gander, and if you're going to have evidence as to one, it's going to apply to the other. But again, this is in large part relying on Williams' testimony. So there's a problematic there in terms of allowing Mr. Hewitt to sit next to Mr. Everett at that table and be tried with him concurrently when he's not allowed to present his testimony from Everett that would undermine or potentially provide larger context to what Ms. Williams is testifying to.
Do you have a case by any chance that you could point me to that's held? I know we don't have that many cases that have reversed on failure to grant a severance in the first place. But in any jurisdiction where the court has found an abuse of discretion for failure to grant a severance when in a separate trial, the evidence would have been admissible anyway as to the co-defendant.
I can't sit here, Judge Deal, and tell you that I do. Just a few points I want to make about the exculpatory testimony point. Obviously, the issue in question, which we've been talking about already, there are 4 factors to the exculpatory testimony prong of the severance argument. There's no question that 2 and 3 are satisfied. The trial court agreed to it, and the government didn't contest that Everett would have presented the testimony and was willing to do so, and that Hewitt wanted to present it. The judicial administration prong, if there's any concern about that, that cannot trump the right to be tried separately if the standard is met. And the testimony with regard to the exculpatory, to give us context of the exculpatory nature of the testimony, it doesn't have to prove actual innocence. It doesn't have to actually prove that Mr. Hewitt was innocent or was completely devoid of presence at the scene, but it does require that it's substantially exculpatory. That's the standard, and it need not be conclusively exculpatory. So we don't have to find that Mr. Hewitt would have been proved innocent by this. And to sort of circle back to my point on this issue, Mr. Everett's proper testimony was substantially exculpatory because it cast doubt on Ms. Williams' identification of the third person allegedly involved in the robbery, that being Mr. Hewitt, of course.
Was there any proper testimony that nickname, I'm not sure I can pronounce it correctly, was not used by your client?
Was there any testimony that was not used by my client? I don't believe there was testimony on that, Your Honor. No. The government also argues that Hewitt was not prejudiced because Everett's proper testimony was presented to the jury by Williams. But as I've already noted, Williams' testimony conflicted itself during the police reports and then subsequently at trial. And she admitted to that at trial, by the way, that she had lied to the government. The government presents several cases on this issue.
But she lied in a way that was most helpful to your client, right? Isn't the testimony that, yeah, I used the word "awk" because I wanted to throw him off the scent, because "awk" could refer to anybody, and I didn't really want to give away my conspirators here. That seems as powerful as the testimony you wanted to put on, which was Ock could refer to anybody. In fact, it seems a little stronger to me than the evidence you could have offered from a co-defendant. Because this is somebody saying, yeah, in fact, I was using that name as a generic name so that you couldn't trace it back to anybody in particular. I mean, wouldn't presenting more evidence like that just be totally cumulative of Ms. Williams' testimony?
The only thing I can say to that, Your Honor, is that the statement that she made was a pre-plea bargain statement. So, you know, what her reason was for originally offering that representation as to, I did it to sort of muddy the waters or lead the government off the scent, I think is similar to how you characterized it. And there's still a reliability issue with her testimony as to what is the motive behind her changing her testimony and her plea. So I'm not casting aspersions on the government's work in this case necessarily. I'm just saying that there's an inconsistency there.
But she also said that the guy was Pencil, right?
Yes,
And
yes.
I mean, was there any dispute that Mr. Hewitt went by Pencil?
I can't dispute that, Your Honor, and I can't dispute, the government mentions the photo array, for example.
So Ock is kind of a sideshow here, isn't it, at the end of the day?
I wouldn't qualify it as a sideshow. I mean, I think how someone is known, what their nickname is or could be is a relevant issue in terms of identification.
Right, but if Mr. Everett had said Ock could have been anyone, but she said, well, whether it was Ock or not, it was Pencil, then whether Mr. Everett said that or not doesn't really matter.
I still think Mr. Everett's testimony is relevant for context outside of how she offered it, but that's all I can say about that, Your Honor. I'm almost done. I just want to make a quick point about the merger argument. There's no dispute here from the government that merger should have occurred. The armed robbery conviction under the double jeopardy clause should have been merged into the felony murder conviction. I would just ask the court to so find and order the trial court to vacate that armed robbery conviction.
Thank you, counsel. We'll still give you some time on rebuttal.
Thank you very much, Your Honor.
Now hear from counsel for the government.
Morning, Your Honor. David Sable on behalf of the United States. In response to the questions from the court, all three judges, Williams testified at trial with respect to her choice of the name. I chose that name. Ock is normally referred to between Muslims, and he, that's Hewitt, was introduced to me as a Muslim man, so that's how I named him. That's what she said on direct. So in response to your question, Judge Fisher, the nickname Ock is in no way inconsistent with identification of Hewitt. Then she said, of course, on cross-examination that she had initially wanted, when she was interviewed by police, to conceal his identity. And again, Your Honor, I think going to your question, anything that Everett could have said about what he thought Williams meant when Williams talked to the police would have been cumulative, far less relevant than what Williams had said herself, which was she was trying to conceal the identity. And that's why she had said that. And she put the information out there. Everett had nothing to add to the testimony of Williams. And then again, of course, what the judge did, Judge Shanker, was that the judge carefully looked at, of course, it was the pretrial context. So what she had in front of her was the statement, the custodial statement. She looked at it. She said, okay, so she initially described the third person as Ock. Then she described him as Pencil. Then the police showed her a photo of a guy that came up in their system as Pencil. And she said, no, that's not him. Then she described him by these physical descriptors. Then they pulled up an array, and then she identified him in the array. And he does go by Pencil. And in fact, his phone number is in the decedent's phone. So again, the court didn't use the word sideshow, but that's essentially what the court found. The whole Ock thing was a sideshow. And if you have any doubt about it, you can see Nikki Lotzi's reaction. She represented Hewitt at trial at the sealed bench conference. She's like, oh, I thought there was more to this. Well, okay.
Sorry, just to clarify on the factual question, was Hewitt's name in the decedent's phone as Pencil? Is that what you were saying? I can check the record.
It was
It's fine. We can go back.
Either it's either in his phone, either the number's in his phone or it's in the decedent's phone, his pencil. I can't tell you. What I do know is the Hewitt's role in this was that he was good friends with Hurd. And so when Everett was talking about let's rob somebody, Hewitt offered his friend, the PCP dealer, Fat Daddy or Hurd, as the target. And so it was Hewitt who made the first call. Hewitt's making calls on text me and through his phone to Hurd. So he's an active participant in the conspiracy. So I don't have that. I could supplement, Your Honor. But again, in response to your question, Judge Deal, I'm not aware of any case where this court has severed on disparity of evidence or severed particularly in a conspiracy context. There was some obstruction evidence which was separate, and the judge told the jury that that's separate. And the jury, of course, did render very separate verdicts on that obstruction evidence. But the bulk of the trial, of course, was the murder. It was a felony murder theory. It was a product of a conspiracy, and Hewitt was an active participant in the conspiracy. If there are no further questions, I would ask that the judgment of the Superior Court be affirmed.
All right, thank you, counsel.
Thank you, Your Honor.
And Mr. Schmidt, we'll give you a little time for rebuttal.
Sorry, I forgot to take the mask off. Just two quick points I want to make. I think the issue of de minimis evidence doesn't address what hasn't been addressed yet, is the fact that there is physical evidence, incontrovertible evidence that puts Everett at the scene of the crime, independent evidence of Ms. Williams' testimony, and that's the video. So there's a significant discrepancy there in terms of the evidence that convicted one as opposed to the other.
There's a difference between the evidence being stronger against one defendant than against the other.
Yes, I think.
And the de minimis standard.
There is certainly a difference, Judge Fisher, in terms of the de minimis standard. There is case law that says it can't just be a strength of the evidence analysis. I admit that. But I would argue that when you have a situation where one defendant is clearly placed at the scene by live video and is filmed killing the victim, I think that's a far cry from the evidence against Mr. Hewitt here. As far as just a quick point, Mr. Sable's a comment about Ms. Lassie's statement. I don't know that we have the context for that, and that's certainly not admissible or relevant in this context as to what the strength of that evidence was. If you want to cite the trial judge's decision, that's one thing, but his counsel's sort of extemporary statement is not sufficient. I think we've made all the arguments we need to make, Your Honors. Unless there are any other questions, we would just ask that you vacate the trial court's decision on severance and send it back, and if not, at the very least, merge the convictions and have the trial court vacate the armed robbery conviction. Right.
Thank you,
very
counsel.
much.
We appreciate the parties' briefs and their arguments. The case will be taken under advisement. All of this morning's cases are submitted and the court stands adjourned.
All right.